Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Colorado and outline some simple steps landlords can take to initiate an eviction. We're eForms, the largest online database of fillable legal forms. In this video, you'll learn what the eviction process looks like, Colorado laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property. This is typically known as a self-help eviction, and it's against the law if the tenant refuses to leave after violating the terms of a lease agreement. A landlord must seek an eviction from the court. Keep in mind that evicting a tenant for cause is different from terminating a lease. If a tenant violates the lease either by not paying rent or not complying with the conditions of the agreement, the landlord can issue what's known as a 10-day notice to quit. The form gives a tenant 10 days to rectify the problem or be evicted. In some cases, there is a grace period set by the lease agreement. If a tenant does not fix the specified problem, the landlord can begin the eviction proceedings by filing two forms called a complaint and a summons with the county court where the property is located. Filing fees range from $85 to $135. After receiving these documents, the court will set a hearing date. The landlord must serve the filed forms on the tenant using a civil process server, or at least 7 days before the hearing. Once the documents are served, the process server will provide an affidavit for the landlord to file with the court. The tenant can protest by filing a form known as an answer. If, however, the tenant doesn't respond within the specified time period, then the landlord can file two documents with the court. The first is a motion for judgment, which indicates to the court what the landlord is demanding. The second is called an order. This form will document a judge's decision. The 10-day notice to quit is not to be confused with a lease termination letter, also known as a no-fault eviction. If the landlord seeks to terminate a tenancy that lasted more than 1 year, whether on a month-to-month or a fixed-term lease arrangement, 90 days notice is required. Additionally, the landlord must generally cite one of the following justifications: selling the property, demolition or conversion of the property, substantial repairs or renovations, landlord or family member moving in, tenant's refusal to sign a renewed lease with reasonable terms, or history of non-payment of rent. For tenancies of less than 1 year, the required notice is as follows: tenancy of 6 months to less than 1 year, 28 days. Tenancy of 1 month to less than 6 months, 21 days. Tenancy of 1 week to less than 1 month, 3 days. Tenancy for less than 1 week, 1 day. We've got everything you need to pursue an eviction in Colorado, from eviction notices to court documents. Click the link below to access it all. And don't forget to hit that subscribe button for more videos about legal issues relevant to everyday life.